I have the privilege and the pleasure to interview Mr. Leonardo who is the CEO and the co-founder of ADR Center in Italy. Since 1988, he has resolved more than 1,000 national and international complex civil and commercial mediations. With 20 years of full-time work in the field of ADR, alternative dispute resolution, Mr. D'Urso is responsible for the managing of ADR centers activities, the opening of 31 resolution centers in Italy, and the creation of ODR Center, an innovative platform, cloud platform developed to manage the mediation process. In 2017, you have been designated by the Council of Europe as a scientific expert in the working group on mediation within the European Commission for Efficiency of Justice. And you have developed the first multilingual platform on cloud for users in order to easily manage from different devices all documents related to a mediation or arbitration procedure. Mr. D'Urso also holds an MBA in International Business at the Thunderbird School of Global Management in Phoenix, Arizona in the United States of America, and an economic degree in Italy. And also he is the author of several books, publications, and video on mediation and ADR, and experienced trainer of mediators and trainer of trainers. Did you miss anything?
It's too much, thank you. Everything is there.
So, welcome to Craiova, welcome to the Dolj Bar Association. We're very happy to have you here, but why are you here?
First of all, thank you for the invitation. I'm it's an honor for me to be in Craiova and to be invited to your bar associations. I am here basically to share my 20 years of experience, my personal experience on mediations from the early days where talking about mediation was kind of a crime. I mean, everyone was laughing at me, to the recent years of success of mediations, and to share also the experience of Italy. Italy has been a laboratory of mediation public policies. We changed the different laws on mediations. Most failed. But in the last years, I think we found a good compromise that now everyone is happy. So I'm here to share the failures and the success of a person in mediation, both from my personal point of view and from the jurisdictions of the Italian point of view.
The Italian mediation model is known to be one of the most successful in Europe. What's the secret? Please present us briefly.
Well, first of all, we have 20 years of experience of different laws, different public policy in mediation in all Europe. So after the 2000 Council of Europe recommendations on mediation and the 2008 EU directives, all countries has implemented these laws in the European directive in different ways. And a couple of years ago, both the Council of Europe and the European Parliament asked me and some of my colleagues to measure the results. What happened after 10 years of the EU directives and after 20 years of the Council of Europe recommendations? The results are modest. I mean, most of the countries, the balanced relationship between the number of mediation and number of judicial proceedings in courts every year is less than 1%. Remember that the Article 1 of the directive say the goal of the directive was to reach a balanced relationship. So that should be balanced, 50-50. And most of the country didn't happen at all. Most of the countries, and I think in Romania as well, out of 100 cases in court, there are only 1 mediation. So something is wrong. And to look at the future, we have to look at the past. I mean, now we have data available, statistics, best and worst experience. So we have to think about it, to study this. And few years ago, in 2013, after different failures of Italian legislation, the Italian government found, I think, a good solution. First of all, called all the stakeholders, judiciary, the Minister of Justice, the judiciary, and the lawyers first, and the mediators associations, and found a good solution on what we called a first mandatory meetings. So it's not mandatory and it's not voluntary, because it's on voluntary. Unfortunately, on poor voluntary mediations, it doesn't work. I mean, for a lot of reasons. Poor mandatory mediation, full mandatory has a lot of problems. It can be against the constitution, like like in Romania, so in many other states. So we found, I think, a good formula, what I consider the magic formula. And basically, and it was introduced as a pilot test for some dispute matters, civil matters, like real estates, division of assets, inheritance cases, banking and insurance contracts, defamations, and few others that count not more than 15%, 15% of whole civil commercial cases. The legislator said, let's try in these dispute matters one new formula, that is, before going to the court, the parties has to meet with a mediator for one first meetings at very low cost, 40 euro, within 30 days of the date of the filing of the mediation. And then with the meetings of with the meeting with the mediators, the parties and their lawyers present, with the mandatory presence of the lawyers, they can make informative decisions. They can opt out, say, okay, I understood what this mediation is about, I don't care, we want to go to the court. Or they can go opt-in. They can opt in and start the full process, agree on the mediation fees. So it's not mandatory and it's not voluntary. It's the mandatory part is only the meeting on the first sessions. Well, the results after 5 years of the implementation of this law are astonished. About a little bit less of 50% of the time, as well, all the parties show up in the first meetings. The parties agrees to go to full mediations, and out of these 50, more than 60% depends they find a solutions. And most important, in these dispute types, in these 5 years, the incoming cases in court dropped from 30 to 50% of the time. So that it doesn't mean that the conflicts are still there, but they are solved outside the court.
Outside the court. Okay. Since I'm a lawyer, is there a role for the Italian lawyers and bar association in this framework of mediation in Italy?
Well, the lawyers they have a key role on mediations. And again, let me share our experience. In 2010, when the first law of mediation was introduced, where it was full mandatory mediation, means that before going to the court, the party has to attend a full mandatory, process and pay in full. All lawyers were opposing this. They went on strike. The bar association were very against this law. Then in 2013, this law, as I mentioned, changed, and just 2 years ago, the main conference, lawyer conference in mediations in Italy, main conference, national conference on lawyers, was titled "Justice Outside the Court." Okay, so basically now most of the lawyers, most of the bar associations are in favor of this law for four main reasons. First, 80% of the mediators are lawyers, so or have retired judges, but most are lawyers. So it's a good opportunity for lawyers to have a different professions. I mean, parallel, I have to say, profession. Second, in all bar associations in Italy, there are more than 100, there is a mediation center now. So all bar associations have a mediation center, and the law gives the rights to open even a center within the court. So all bars has 1 or 2 rooms within the court to administer mediations. Third, another important issue is that our law introduced a provision that when a settlement agreement is signed by the lawyers, by the 2 lawyers, that settlement agreement is automatically enforceable title. So without going to the court, back to the court. So this was the first time that lawyers had this power. So basically, they said with their signature, they certified that that settlement comply with the general law. So they have responsibilities and they get paid for this. And then fourth, a few years ago, the Bar Association, the National Bar Association, introduced specific fees for lawyers to assist the clients in mediations. These fees are very competitive, of course, a little bit less, of course, of going to the litigation, but mediation is 3 months, is a maximum 3 months. So lawyers now are happy and with the mediation process.
Okay. So, given your expertise in this field and the current local circumstances that you may be aware of, what options could be considered to improve the mediation activity in Romania?
Again, I mean, I don't want to tell you that to import directly the Italian law in Romania. I think that you should see and study the experience, again, your experience and the experience of the best practice of the other countries, and find your way, your best way. I mean, the Italian way has been proven to be a good experience and deliver good results. Our law is based on 3 or 4 pillars. One is these first meetings that I was telling, and this is important, not introduced from one day to another, but is gradually. So it means just maybe as advice, I can advise, think about to introduce these first meetings in some dispute matters, not all, in some dispute matters, and then monitor the result after 1 or 2 years. This is one possible solution. Second one is the referral. So our law, there is a provision where the judges can always refer the parties to mediations, and they do not have any impact on the duration of the judicial proceedings, because usually the time span between hearings are 4 to 6 months. So what the judges they do usually is they set the date of the next hearing in 6 months, in 4 months, but in the meantime they actually order the party, try a first meetings in the meantimes. Go to a mediator, pay only €40, see if can help, if the mediator can help you, and if you settle, we consult. And this is great. We are starting some project in courts where law students or fresh graduates can assist the judges to select the pending cases to some criteria, and help the judges to write the order with some reasoning, of course, for the party to refer cases. So these are some good advices that maybe the Minister of Justice, the Bar Association can consider. And one my last advice is the bars and lawyers should lead the way and should pretend to have a high quality service on mediation, based on mediators that they know the law, they know the parties, and so on.
I'm afraid that what happened in Italy 9 years ago is happening right now in Romania. Mediation is a relatively recent activity in Romania, and it's notorious that, at least for the beginning, was not very popular among the Romanian lawyers, quite the opposite at times. And it was seen as a threat to a lawyer's interest. How can these two activities conciliate in the future?
Well, I mean, this is not a problem of Romania, believe me. Is in whole jurisdiction. I'm doing projects and trying. I'm kind of an ambassador of the Italian model in the world. So I was last week in Kenya with a regional conference in Africa. I have a project in Azerbaijan, in Serbia, and in Turkey, in many countries. And this is a common problem, a common perception, no problem, perception of lawyers. And there's this joke that ADR stands for alarming dropping revenues. So lawyers everywhere are a little bit scared of mediation, that is against their interest. First of all, I think he needs to explain what mediation is, and giving the workshops for lawyers. And this was a problem of Italy, for example. In whole school of laws, the students and lawyers learned how to litigate in court, but there was no class on negotiation techniques, no class on mediations, how to solve the problems, and lawyers had to learn on day by day, but not in university. So it was a tool that was not given to lawyers. So a starting point is, held some workshops and to lawyers how to help them to solve problems in direct negotiations with negotiation techniques, and how to master, and through mediations. And then, of course, there's the economic aspect is important, of course. I mean, and I understand that the mediation can be seen as a threat on the revenues of lawyers. One solution, as I mentioned already, in Italy was first where this mandatory, this first meeting is mandatory, the presence of the lawyers is mandatory as well, first. And second, set clearly fees for what we call mediation advocacy. So this is the lawyers has an important role in mediations, and the lawyers are the gatekeepers. It's the lawyer that selects a mediation center, they select a mediator. So it's a new way, and I think my suggestion again is lawyers, they should lead the way. And this new movement, it will come in one way or another. It's impossible to have an efficient judicial system without a good mediation practice. Of course, mediation is not a panacea. It will not solve all problem of inefficiency of justice. It's just one element. But this element, like in the United States for 40 years and all over, is led by lawyers and judges.
Any message or word of advice for the members of the Dolj Bar Association?
Well, again, I'm honored to be here, but maybe a first step is, as I always mention, is maybe learn what mediation is, and learn what is the role of the lawyers in a mediation process. In the United States, not only the training course how to become a mediators, but there are now getting very popular course how to win in mediation, how to spin the mediators. Basically, lawyers that use the mediators to reach for their clients better deals. So my advice is maybe, and I will happy to help to start a series of workshops. Half days will be fun, will be sufficient to learn negotiation techniques for lawyers and mediation techniques for lawyers.
Thank you very much, Mr. URSO.
You're welcome. Thank you, Andrei, for inviting me.